Categories of law. What is the source of the law? In this section, we're going to review 5 different sources of law. Constitutional law is law which comes from the Constitution itself. Statutory law is law which comes from the legislature's lawmaking process. Administrative law comes from the executive agency's regulation and rulemaking powers. Common law comes from the courts in the form of case law, and executive orders come from the president. Let's review each of these individually. Constitutional law can come from either the state constitution or the federal constitution. Each state has their own constitution, and specific laws flow from it, just as the federal constitution gives us laws like the Bill of Rights. The California Constitution is located at leginfo.ca.gov if you're interested. If you hadn't read it, it's a good thing to read. There are a lot of rights in there which aren't covered by the federal constitution, which you as a Californian have under the California Constitution. If you're not from California, look up your state legislature's website, and they'll give you the link for the Constitution of your particular state. We protect constitutional rights in 2 different ways, through civil rights and civil liberties. And all constitutional law has to do with actions which involve the government. So let's talk a little bit about those. Civil liberties are known as negative rights. They're limitations on what the government can actually do. And so saying that the government can or cannot do something would be part of a civil liberty. They protect our right to think and act without governmental interference, and they keep the government at bay. Civil rights, on the other hand, are positive rights. They're protections provided by the government. So instead of stopping the government from doing something, they're things which the government is responsible for in order to create the just society which we enjoy. So this is an extension of government action to secure citizenship rights for all members of society, and laws to make sure that we treat each other equally under the law. Civil liberties can be found mostly in the Bill of Rights, civil meaning of citizens, and liberties of personal freedoms. So what are the personal freedoms of the citizens of the United States who are protected by the federal Constitution? Well, we have the Bill of Rights, which includes both civil law and criminal procedures. The First, Second, Third, and Seventh Amendments to the Constitution lay out civil right protections that we have which are civil liberties, and the Fourth, Fifth, Sixth, and Eighth Amendments to the Constitution lay out the criminal procedure. The Bill of Rights is actually not a very long document, and I suggest reading through it if you haven't already. We're going to just very quickly go through what some of the rights that you have are in the first 8 amendments. The first 8 amendments are all individual rights. They're all things which you as a citizen can avail yourself of or make use of. The first amendment to the Bill of Rights you've probably heard of before. This is the freedom of speech, the freedom of press, assembly, the freedom to petition, and the freedom of religion. We hear about that one quite a lot, and it's oftentimes in the news. The Second Amendment is the right to bear arms, which you probably heard of as well. The Third Amendment maybe not so much. It says no quartering of soldiers. We had a problem with this back in the time of the Constitution, in that the government, when they wanted to move soldiers around, they would place them in the homes of ordinary citizens. So they just knock on your door, let you know that the soldiers were going to be staying there, and you were going to provide for them food, shelter, anything that they needed for the amount of time which they were there. Oh, and by the way, you didn't get paid for it. This was your civil duty. The Fourth Amendment is no unreasonable searches and seizures. It also includes the exclusionary rule, which says that some evidence, if it's tainted, can't be used in a court proceeding against you. The Fifth Amendment is your right to just compensation for taking. It's also your right against compulsory self-incrimination. It's your right to be free of double jeopardy, and your right to a grand jury indictment. We hear about the self-incrimination thing a lot. You have the right to remain silent. That's where this comes from. The right to a just compensation for taking is known as eminent domain. Sometimes the government needs land for certain things, and so they can go in and take it. They can say, I'm building a freeway through this particular piece of land, and so we're going to need your property in order to build our freeway. What this right does is it ensures that you actually get some sort of just compensation for it. You get paid a fair market value for the actual land which is being taken. No double jeopardy and the right to grand jury indictment both have to do with your criminal law defenses, criminal law rights, which are reserved in criminal procedure. The Sixth Amendment is the right to a public trial, right to a counsel in criminal cases, right to confront witnesses, this is called the Confrontation Clause, right to an impartial jury, right to a speedy trial, and right to a jury in criminal cases. As you can see, this has a lot to do with the criminal procedure which we mentioned on the previous slide. The Seventh Amendment is a right to a jury in civil trials, and the Eighth Amendment is no cruel and unusual punishments and no excessive fines or bail. The Ninth and Tenth Amendments actually have to do with things which are actually allocated to the states. So they aren't individual freedoms, which we don't go over here, but they're worth the read to complete your education of the bills. Civil rights are different. They also come from amendments, but they don't come from the Bill of Rights itself. The 13th, 14th, and 15th Amendments, for example, all came out of the Civil War, and they have to do with the freedom of slaves, they have to do with Reconstruction, and they have to do with voting, as seen in the 19th and 26th Amendments. Legislation, judicial review, and decisions, and executive orders can also have civil rights. So you're not actually only looking for them in the body of the Constitution itself, but in different things which are going to interpret and talk about the Constitution, and in different parts of the law which allow you to use the Constitution to branch off and do other things. The goal of civil rights is to treat all citizens equally, apply laws fairly, and not discriminate unjustly. The 14th Amendment, as listed here, has a couple of protections. One most famous is the Equal Protection Clause, which says just this, that all citizens are entitled to equal protection under the laws. Statutory law. Statutory law comes from, it gets its name from statutes. What statutes are the laws and codes which are actually written down by legislative bodies. When the legislature sits around together and they hammer a bill into a law and then it goes into the books, this is called a statute. It's a federal or state law written and enacted by the Congress or state legislature, respectively. When it's a federal statute, then it was enacted and written by Congress. If it's a state statute, then it was written and enacted by the state legislature. Local legislatures can also enact statutes, but when they do this, we call them ordinances. So you may hear of your local city ordinance, for example, which was put into place by your local city government, headed up by your mayor. But when you're looking to ordinances, please make sure to look at each specific jurisdiction. Different ordinances can come out of different cities, and so crossing the border into another city may change the ordinances that you're dealing with. Look to your city council's website for information about your local ordinances. Common law and case law. These are reported decisions of appeals courts and other courts which make new interpretations of the law and therefore can be cited as precedents. Popular to contrary belief, not all courts have the power to make law. In fact, contrary to popular belief, courts can make law in the first place. It's something that not many people think about. But what happens is when you get a court of appeals or a Supreme Court, a higher court which makes decisions that other courts must follow, then law is made. Because when lower judges and lower courts have to look to higher courts to see how they decided a case, then they're following that particular precedent. Study case law to understand the application of law to facts, and learn the court's subsequent interpretations of the statutes. This helps us further the statutory interpretation of different parts of the law that the legislature has enacted. The role of the judiciary, as we'll speak about later, and much of the course, is to interpret law. And so oftentimes, the way that this type of law is made is by taking a particular statute which has been brought before the court, and the judge interpreting it in a certain way, and then that interpretation being followed by lower courts, and that's what we call common law. Let's talk a bit about how judges do this type of interpretation. Like I said, you have the statute. And then say judge number one has the statute brought before them. There's a certain case where the statute applies, but they're not exactly sure how it applies because it doesn't exactly fit the bill for perhaps what the statute was drafted for in the first place. And so the judge will make a ruling. He's going to give a new meaning of the part of the statute and address a part of the statute and make a new meaning which is going to be brought forward into the next cases. When case number 2 comes up in front of the second judge, then they're going to look to case number 1 to see what the first judge said that part of the statute meant. They're going to read the meaning and then apply it, and sometimes then put their own new meanings on top of that case as well. Same thing happens when it comes to a third judge, and so you have different interpretations of the same statute by 3 different judges who can often look to each other to see how different courts have interpreted the same language and which guide them on how to make their new common law. Next we have administrative law or regulatory law. These are procedures which are created by administrative agencies themselves. Administrative agencies are actually executive agencies. They're governmental bodies. They can either be under the federal government or all the way down to your local city or county. They involve rules, regulations, applications and licenses, permits, available information, hearings, appeals, and decision making. For example, these would be the types of rules which govern the DMV in your local area. We often find these in administrative regulations, which say exactly how many minutes have to happen during an eye exam for the DMV, how much of the test needs to be completed, for example. And oftentimes there are many, many rules and regulations within the structure which have to be exhausted before a lawsuit can be brought in civil court. If you're not happy with the way that something happened within an administrative setting, oftentimes you have to go through all of the grievance procedures within that administrative setting, following all of their rules and regulations, and even sitting before an administrative law judge before you can bring a lawsuit in civil court. Lastly, we have executive orders. Executive orders come from the executive of a particular jurisdiction, giving a declaration which has the force of law. So think of the president, but this can also be the governor. These are usually based on their currently existing statutory powers, but they require nothing from Congress at all. So executive orders are a very interesting beast. You might not be aware that they exist at all. Usually it's not the power of the president to make laws. We leave that up to the legislature. The power of the president, as you probably heard before, is to execute the laws. So why is an executive order being made in the first place? Sometimes the president or the governor has to clarify what they meant by a particular statutory power that they exercised. And so they'll write executive orders to give clarification to the people who are going to carry them out. A couple of things to know about executive orders. You can get rid of them. Because Congress is the real lawmaking body, if Congress legislates and decides to make a law which overrides or changes the executive order, then the executive order goes away. The court can also overrule the executive order by saying that it's unconstitutional. Or a following president can come in and rescind the order, saying that they're replacing the order with something else, or they're just taking it back. So even though the executive has the power to do this, we have many checks and balances in place which allow for no abuse of power to happen in this particular instance. At least that's the idea. A good example of this is President Truman actually banned segregation in the armed forces using an executive order. How did he get away with that? Well, the president has certain powers, including a power in which he is called the commander-in-chief. You've probably heard of this before. The president is the head of all of the armed forces of the United States. And so he used his position as commander-in-chief to draft an executive order in which he regulated his statutory power to be in charge of the rules of the armed forces. And he did this and banned segregation during his time in presidency. So let's quickly go over which brand of government makes the law. Well, constitutional law is going to be made, of course, by the Constitution, and so that's something that won't really fit into our tree here of legislative, executive, and judicial. However, constitutional law is interpreted by the judicial branch. Statutory law is law which is created by the legislative branch, by a legislature sitting down and writing the laws. Administrative laws are created by administrative agencies, which are a part of the executive branch. Common law is law in which judges have created by interpreting the statutes which are brought before them, so that goes to the judicial branch. And executive orders are laws which are put in place by a president or a governor, who are both part of the executive branch. So from what we've learned of the different types of law, we now know that we can mix and match. You can have a substantive law which is civil and statutory. You can have a substantive law which is civil and common. You can have a procedural law which is a criminal law and statutory. You can have a procedural law which is a criminal law and constitutional. Here are some examples. Here's a law from the California Penal Code. Section 451 says that arson that causes great bodily injury is a felony, punishable by imprisonment in the state prison for 5, 7, or 9 years. Well, this is a substantive, not a procedural law, because it regulates specific conduct. It's saying, thou shalt not burn people in a way that creates great bodily injury. It is a criminal law because of the remedy. The remedy says that the person will be imprisoned in the state prison for 5, 7, or 9 years. Remember, when we're looking at civil versus criminal, you're often looking at what the remedy is which is being sought. If you're seeking to incarcerate somebody, it is always a criminal law. And then finally, the law is statutory. We have the California Penal Code, which is part of the set of laws which is written and enacted by the state legislature. Our second example is from the U.S. Constitution, the 14th Amendment. It says, "No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law." This actually includes two different clauses, which we know as the Privileges and Immunities Clause and the Due Process Clause of the U.S. Constitution. So let's talk a little bit about this particular clause. This law is procedural because, unlike the substantive law, which regulates some sort of conduct, we're not talking about conduct here. We're talking about a procedure which has to happen. The state cannot deprive a person of life, liberty, or property without due process. This is also a civil law. It doesn't say anything in here about a way to incarcerate or fine an individual, but rather talks about what the state can and cannot do. And lastly, we see that the law is constitutional. We see that the law itself came from the U.S. Constitution, and since the source of the law is the U.S. Constitution, or if it was the California Constitution, then we can say that it is a constitutional law.